Imagine for a second that you're one of the founding architects of a brand new nation. You've just, overthrown a colonial power, the country is fractured, poverty is absolutely rampant, and you're sitting in a humid room in New Delhi trying to write the rule book for the future.
It's an immense task, hard to even comprehend.
It is, and you have these massive, ambitious dreams. You want to end hunger. You want to ensure every single worker gets a fair wage. You want to protect the environment and make sure justice is free for the poor. So you write all of this down in incredible detail.
It sounds like a utopia. Or, at least a very ambitious manifesto for a...
Tiny little clause that says to the courts, by the way, you can never force the government to actually do any of this.
It does sound like a paradox. Or to a cynic. Maybe even a cruel joke.
Right. It's like writing a check for $1 million and then telling the bank, this is valid, but you're legally forbidden from ever cashing it. But, and this is the key, this isn't a hypothetical. This is exactly what we are dealing with today.
We're talking about a set of instructions that Dr. B.R. Ambedkar called novel features.
Yes. But critics at the time, they dismissed them as paper tigers or just, New Year's resolutions that get broken on January 2nd.
And yet, despite that criticism, these very principles have shaped everything from our land laws to the way our villages are governed. Today, we are decoding the conscience of the Indian Constitution, the directive principles of state policy.
Welcome back to the Deep Dive. This is a very special session, and it's presented by Simplified UPSC by PPP. If you're a serious aspirant, or frankly, just someone who wants to understand how India actually works, you are absolutely in the right place.
We're glad you're here.
Before we jump into this legislative labyrinth, I do have a humble request. If you find value in this breakdown, and trust me, we're going to go significantly deeper than your standard textbook summary today, please take a moment and subscribe to the YouTube channel.
It really helps.
It does. And if you're capable, please consider joining the paid membership on YouTube. It's what supports our mission to keep bringing you this kind of super useful content.
We really appreciate that support. It genuinely keeps the research engines running and lets us go into this level of detail.
And on that note, a huge shout out to all our existing members. Your support is what makes this kind of deep analysis possible, so thank you. Also, don't forget to like the video and share your valuable comments. We really do read them.
And the notes. We always get asked about the notes.
Yes. Okay, for all the learners asking about materials, the free notes, which include practice previous year questions or PYQs, are available on our Telegram channel. The link is down below.
But if you want the premium stuff...
Right. If you want the premium notes, extra PYQs, and model mains answers, and this is a big one legend, YouTube members should hop into our Discord channel.
That Discord channel is a goldmine for mains preparation. I mean, the model answers alone are worth the price of admission.
It really is. Okay, let's get down to business. Today's mission is clear. We are breaking down Chapter 9 of M. Laxmikanth's Indian Polity, the 8th edition.
The topic is Directive Principles of State Policy, or DPSP, as you'll often see it abbreviated. But we aren't just summarizing the chapter.
No.
We are linking every single concept we discuss to actual UPSC prelims and mains questions from 2013 all the way up to the 2025 cycle. We want to show you not just what the book says, but how you can use it to score marks.
Let's unpack this then. Part 1, the novel feature. First off, the geography of the Constitution. Where do we physically find these principles?
Okay, so if you were to open the Constitution, you'll find them in Part 4.
Part 4, okay.
Specifically, they cover Articles 36 to 51, and it's important to note it sits right after Fundamental Rights, which is Part 3.
And we didn't just invent this idea out of thin air, did we? The Constituent Assembly was looking around the world for inspiration.
No. Absolutely not. The framers of the Constitution they were brilliant students of global governance. They borrowed this concept from the Irish Constitution of 1937.
And the Irish, where did they get it?
They actually copied it from the Spanish Constitution. So there's a lineage of ideas, traveling from Spain to Ireland and then to India.
That's fascinating. So what was the core idea?
The core idea was to have a set of ideals, a sort of moral framework that the state should keep in mind when it's formulating policy and enacting laws.
Dr. Ambedkar called them novel features, right?
He did. He saw them as something really special.
Yeah.
And Granville Austin, who's a very famous constitutional historian, described the directive principles and the fundamental rights together as the conscience of the Constitution.
I love that phrase, conscience of the Constitution. It implies a moral compass for the nation.
It does.
But that brings me back to the big question, the one I started with. If the government ignores these principles, if they don't provide a living wage or they don't protect the environment, can I go to the Supreme Court and sue them?
And the short, simple answer is no. They are non-justiciable.
Non-justiciable. Okay, let's define that clearly for everyone listening.
It means that these principles are not legally enforceable by the courts if they're violated. This is explicitly stated in Article 37.
So the Constitution itself says, don't take this to court.
Pretty much. Article 37 declares that these principles are fundamental in the governance of the country, and it says it's the duty of the state to apply them when making laws. But, and this is the crucial part, it also says they shall not be enforceable by any court.
So I can't file a writ petition.
You can't. You can't go to the high court and say, the government hasn't enacted a uniform civil code yet, so please force them to. The court will just throw it out.
Why? Why give us this powerful list of instructions that we can't actually enforce? Laxmikanth lists a few reasons, but it just feels so counterintuitive.
Well, it really comes down to pragmatism. When India was born in 1947, the country had, to put it mildly, inadequate financial resources.
We were broke.
We were. So you can't make something like right to work a legally enforceable right if the government literally doesn't have the money to pay everyone. Yeah. If it were justiciable, the government will be bankrupt in a week from all the lawsuits.
That makes sense.
Secondly, the immense diversity of the country made a uniform, immediate application of all these principles very difficult. Just think of the sensitivities around the Uniform Civil Code, even today, let alone back in 1950.
So it was a timing and a resource issue.
Exactly. And thirdly, there was the burden of being a newly born state. The framers felt the government should be free to decide the order and the timing of these reforms based on what's possible, on the resources available. They didn't want the courts dictating the national budget.
So if the courts can't enforce them, who does? Who holds the government accountable if they just ignore Part 4?
The real force, as the book puts it, is political. It's public opinion.
The voters.
The voters. Polity Krishna Swami Iyer, who was a member of the drafting committee, he noted that no ministry can afford to ignore these principles and expect to survive the electorate. If a government consistently ignores the welfare of the people, they answer for it at the ballot box, not in the witness box.
That's a fantastic distinction. The court of law versus the court of public opinion. Essentially, the Constitution is saying, if you don't do this, the voters will fire you.
That's the mechanism.
Okay, now let's move on to the structure. Laxmikanth mentions that the Constitution itself doesn't formally classify these principles. It doesn't have sections labeled Socialist, Gandhian, and so on.
That's right. The Constitution just lists them numerically, from Article 36 to 51. But for the sake of study and analysis, scholars have grouped them into three broad categories, or buckets, based on their ideological source.
And those are?
Socialistic, Gandhian, and liberal intellectual.
Let's dive into that first bucket, the socialistic principles. This seems to be where the heavy lifting happens, especially regarding the economy.
It is. These are the principles that aim to create a welfare state. They're trying to achieve social and economic democracy. You see, the fundamental rights gave us political democracy, one person, one vote. These principles want to ensure that vote actually means something by giving people a baseline of economic security.
So what are the key articles here that aspirants absolutely need to have memorized?
Well, Article 38 is the big one. It directs the state to promote the welfare of the people by securing a social order permeated by justice. And it specifies social, economic, and political justice.
And that phrase, economic justice, is key.
It's crucial. Then you have Article 39, which is quite dense and very, very important for UPSC.
39 gets cited in court cases all the time, doesn't it?
Constantly. Specifically, you need to know Article 39B and 39C.
Okay, break those down.
Article 39B says that the ownership and control of the material resources of the community should be distributed in a way that serves the common good.
So resources shouldn't just be for the rich.
Exactly. And Article 39C takes it a step further. It says that the operation of the economic system should not result in the concentration of wealth.
Wow. I mean, those sound like direct challenges to unchecked capitalism.
They are. They form the entire philosophical basis for things like bank nationalization and the Land Reform Acts. Then you have Article 41, right to work, to education, and to public assistance in cases of unemployment, old age, sickness, and disablement.
Okay, this is where it gets really interesting for our listeners. You promised us links to exams. How does UPSC actually ask questions about this stuff?
All right, let's look at the 2013 prelims. There was a question that asked, and I'm paraphrasing slightly, Economic justice as one of the objectives of the Indian Constitution has been provided in.
And what were the options?
They give you options like the preamble and the fundamental rights, or the preamble and the directive principles.
That's a classic trap.
It's a total trap because your mind goes to justice and you think fundamental rights.
But the answer was
The preamble and the directive principles. This links directly to Article 38. Fundamental rights are mostly about political justice, freedom of speech, equality before the law, but economic justice. That's found in the preamble's goals and explicitly in the DPSP's Article 38. If you ticked fundamental rights, you got negative marks.
That is such a crucial distinction, political democracy versus economic democracy.
It's the core of it. And then again, in the 2017 prelims, a question came up about the right to work and right to education. Now, many students get confused because we do have a fundamental right to education now under Article 21A.
For children, right?
For children between 6 and 14. But the broad right to work, that remains strictly a DPSP under Article 41. It's an aspiration, not a guarantee.
So if you see right to work on a prelims paper, your brain should immediately scream DPSP, not fundamental rights.
Precisely. You have to distinguish between the goal, which is the DPSP, and the legally guaranteed right, which is the FR.
Let's move to the second bucket, Gandhian principles. This feels very unique to India, right? You probably won't find this in the Irish or Spanish constitutions.
No, this is completely homegrown. These principles represent the Reconstruction program that Gandhi talked about all through the national movement. The framers wanted to ensure his vision of a village-based, self-sufficient, nonviolent economy was embedded in the Constitution's DNA.
What are the heavy hitters here? What are the articles we need to know?
Article 40 is the absolute superstar of this category. Organization of village panchayats. Gandhi believed in Gram Swaj, or village self-rule. He hated the idea of every decision being made in a big city like New Delhi.
And that's a huge part of our governance structure now. Then we have Article 43, which promotes cottage industries. That has a very Khadi vibe to it.
Absolutely. And Article 47, which calls for the prohibition of intoxicating drinks and drugs. That's the basis for prohibition policies we see in states like Bihar and Gujarat today.
And the really controversial one.
Article 48, prohibiting the slaughter of cows, calves, and other milch and drag cattle.
That one is frequently and very heatedly debated.
It is. But for the exam, purely from an exam perspective, you just need to know it sits under the Gandhian principles of DPSP.
Okay, let's connect this to the PYQs. What has UPSC asked from this section?
Let's go back to the 2013 prelims again. The question was about the main task of panchayats. The correct answer linked to the preparation of plans for economic development and social justice. This directly connects Article 40 to the 73rd Constitutional Amendment.
It's so interesting how a DPSP-like organizing panchayats sat there on paper from 1950 all the way until 1992 before it really got teeth with the 73rd Amendment.
That's the perfect illustration of how DPSPs work. They're aspirational goals, waiting for the political will and the societal resources to become law.
Okay, on to our third and final bucket, the liberal intellectual principles.
Right. These are the principles that align more with Western liberalism. They focus on things like modernization, civil rights, and international cooperation.
The most famous, or maybe infamous one here, has to be Article 44.
Without a doubt. The Uniform Civil Code, or UCC. The article states, the state shall endeavor to secure for the citizens a uniform civil code throughout the territory of India.
This one is always in the news. It's essentially saying that personal laws, marriage, divorce, inheritance should be the same for everyone, regardless of their religion.
That's the idea. And it was a direct question in the 2015 mains. The question explicitly asked you to discuss the factors that were inhibiting India from enacting a UCC. You simply can't answer that question without understanding Article 44 as a liberal intellectual DPSP and the friction it causes with religious personal laws, which are protected under fundamental rights.
A real clash of principles. What else is in this bucket?
Article 50, separation of the judiciary from the executive.
Wait, I feel like I've seen a question on this one pretty recently.
You have. In the 2020 prelims, there was a question that asked, the separation of the judiciary from the executive is enjoined by. And the options were things like the preamble, the DPSP, the 7th schedule, or just conventional practice.
And the answer is DPSP.
Yes. Specifically Article 50. It's funny because many people assume this is some kind of basic structure feature or it comes from a specific law, but the actual textual source in the Constitution is the DPSP. It's the principle that says the district collector, who is executive, shouldn't also be acting as the chief judge. We need to keep those powers separate to ensure fair trials. This concept has also become very relevant in the context of the 2025 exam cycle, with all the discussions around judicial appointments and independence.
Makes sense. And finally, Article 51.
That one is about the promotion of international peace and security. This is really the bedrock of India's foreign policy ideas like non-alignment, pan-Shield, respect for international law. It's all grounded right there in Article 51.
So we have these three buckets. But the Constitution isn't a dead document. It evolves. This list of DPSPs wasn't set in stone in 1950, was it?
Not at all. It grew over time, and the biggest change came during the emergency with the 42nd Amendment Act of 1976.
Ah, the mini-constitution. Indira Gandhi's government changed so much of the document then.
Exactly. And she added 4 new directive principles. And you absolutely have to know these because UPSC loves asking which amendment added this particular thing.
Okay, let's list some.
First, Article 39, securing opportunities for the healthy development of children. Second, Article 39A, which is crucial, to promote equal justice and to provide free legal aid to the poor.
So if you're poor, the state has to provide you with a lawyer.
That's the duty. Third, Article 43A, to take steps to secure the participation of workers in the management of industries. And fourth, Article 48A, to protect and improve the environment and to safeguard forests and wildlife.
That covers a huge amount of ground, from workers' rights to environmental protection.
And yes, there is a PYQ. The 2017 prelims specifically asked, which of the following principles was added by the 42nd Amendment? The answer in the options was the participation of workers in the management of industries, which is Article 43A. If you didn't memorize which amendment added what, you lost those marks. Simple as that.
What about the 44th Amendment in 1978? That was the post-emergency cleanup by the Ch9 government. Did they add anything?
They did. They added one major clause to Article 38. It requires the state to minimize inequalities in income and also in status, facilities, and opportunities. So notice the difference. The 42nd was about environment and workers. The 44th was about tackling inequality.
And there was a more recent one, wasn't there? The 97th Amendment in 2011?
That's right. That added Article 43B, which is about the promotion of cooperative societies. This gave a new constitutional impetus to the whole co-op movement in India.
Okay, let's shift gears now to what I think is the most dramatic part of this entire chapter. We have fundamental rights in Part 3, which are justiciable. The courts defend them aggressively. And we have DPSPs in Part 4, which are not. So what happens when they clash?
The judicial tug-of-war. This is genuinely one of the most significant and fascinating legal battles in Indian constitutional history.
So walk us through it. Let's say a fundamental right says, I have the freedom to practice any profession under Article 19, but a DPSP says, we need to set a minimum wage, which might hurt your business profits. Who wins?
In the early years, the Supreme Court was very, very strict. In the famous Champakamdari-Rajan case of 1951, the court basically said fundamental rights are supreme, DPSP are subordinate, they're subsidiary. If there's a conflict, the fundamental right wins, period.
So DPSPs were the clear losers in round 1.
And round 2 was even tougher for them. The Golak-Nath case in 1967. Here, the court said fundamental rights are sacrosanct. Parliament cannot even amend them to implement the DPSPs.
That sounds like a complete deadlock. The government wants to do land reforms, which is a DPSP, to help the poor, but the court says you can't touch the right to property because that was a fundamental right back then.
Exactly. And this led to a massive conflict between Parliament and the judiciary throughout the late 60s and early 70s. This conflict resulted in the 24th and 25th Amendments, and finally the legendary Kesavananda Bharati case in 1973.
Which gave us the basic structure doctrine.
Right. But for the purposes of this conflict, what's the current position? If you're writing a mains answer today, what do you say?
Yes. What's the final verdict?
The final verdict, the current standard, was set in the Minerva Mills case of 1980. The Supreme Court laid down the law. The Indian Constitution is founded on the bedrock of balance between fundamental rights and DPSP. They are like two wheels of a chariot.
That's a beautiful analogy. Two wheels of a chariot.
One cannot destroy the other. The court said you can't sacrifice fundamental rights entirely for the sake of development, but you also can't let fundamental rights completely stall all development. Harmony and balance are key.
But there's a very important exception to this balance idea, right? You need to know about Article 31C.
Article 31C. This is the aha moment for many students when they're studying this.
It's a real game changer.
It is. Article 31C basically says that if a law is made to implement the DPSP under Article 39B, which is about distribution of material resources, or Article 39C, which is about preventing the concentration of wealth, then that law cannot be declared void just because it violates Article 14, which is equality, or Article 19, which is freedom.
Wait, say that again. So in the specific case of economic distribution and fighting wealth concentration, DPSP actually trumps certain fundamental rights.
Exactly. For those two specific articles, and only those two, the DPSP has been given the upper hand. This is absolutely crucial for understanding how land sealing acts and the nationalization of banks survive legal challenges in court.
This leads us perfectly into the analysis for mains. We've established what they are, what the articles say, and the legal battles they've been through. But from a mains perspective, we need to analyze their utility. If they aren't fully enforceable, are they really useless?
Not at all. And that's a common trap students fall into, calling them useless. They serve at least three critical functions. First, they are an instrument of instructions for the legislature and the executive. They set the national agenda. When a new government comes into power, they don't start from a blank slate. They look at Part 4 to see what the Constitution expects them to do.
Okay, an agenda setter. What's the second function?
Second, they serve as a guide for the courts in judicial review.
How does that work?
When a court has to decide if a restriction placed on a fundamental right is reasonable or not, they often look at the DPSP. For example, if a law restricts your freedom of business, but it does so in order to implement a DPSP, like banning child labor, the court will likely say that restriction is reasonable and therefore uphold the law.
So they help define reasonableness.
Precisely. And third, they provide stability. They ensure policy continuity. Governments change. We go from Congress to BJP to various coalitions. But the DPSP remains constant. The destination, the goal for the country, remains the same. Only the path or the speed changes.
Let's look at the scoreboard then, the actual implementation. Critics called them paper tigers, but surely some things have been achieved over 75 years.
Oh, a lot has been achieved. Let's be clear about that. To fulfill economic justice, we had the Planning Commission, and now we have the NITIOG. That is pure DPSP implementation.
Yeah.
To implement Article 39 about the distribution of resources, we had the abolition of intermediaries like zamindars and widespread land reforms. To make Article 40 a reality, we passed the 73rd Constitutional Amendment for panchayats. For Article 48A, the environment, we have the Wildlife Protection Act of 1972 and the Forest Conservation Acts.
What about legal aid?
For Article 39A, free legal aid, we have the Legal Services Authorities Act of 1987, which established look-at-a-lots all over the country.
So they aren't just paper tigers. They have teeth, but only if and when Parliament decides to give them teeth through legislation.
That's the perfect way to put it. They are sleeping tigers until Parliament wakes them up with a specific law, and this is what connects to some very deep and analytical mains questions.
Like the one in 2015 mains, there was a question on cooperative federalism.
Right. The question was, the concept of cooperative federalism has been increasingly emphasized in recent years. This links directly to how DPSP guides center-state relations. Development, which is the core of the DPSPs, requires the center and the states to work together. You can't achieve Article 47 public health if the central government and the state governments are constantly fighting.
And then there was that brilliant 2013 mains question about pressure group politics and the Nagas, which involves Article 371A.
That was a fantastic question. It forces you to see the tension between development, which is driven by the DPSP, and specific rights or regional autonomy. The DPSP often pushes for uniformity and modernization, but something like Article 371A protects Naga customary law. It's a conflict between the modern state vision of the DPSP and the federal and cultural protections elsewhere in the Constitution.
One more that stood out to me was the 2016 mains question that referenced Professor Amartya Sen.
Yes, that was about how Professor Amartya Sen has advocated important reforms in the realms of primary education and primary health care. This is a direct critique of the state's failure to fully implement Article 45 on education and Article 47 on nutrition and public health. The question asks you to suggest measures.
So essentially, it's asking, why haven't we fulfilled these DPSPs yet, and how can we do it?
Exactly. It's using the DPSP articles as the benchmark to measure the government's success or failure. If you just write in your answer, healthcare is bad, you sound like a complainer. If you write, the state has not fully upheld its duty under Article 47, you sound like a civil servant.
That's the language of the exam, absolutely. Okay, before we wrap up, let's do a rapid-fire comparison. This is a classic question. Fundamental rights versus DPSP. I'll give you the category, you give me the key difference.
Ready, let's do it.
Nature.
Fundamental rights are negative. They prohibit the state from doing certain things. Don't arrest me unjustly, don't silence my speech. DPSPs are positive. They require the state to do things like build schools and provide work.
Goal.
Fundamental rights are about establishing political democracy. DPSPs are about establishing social and economic democracy.
Sanction. What's the force behind them?
Fundamental rights have a legal sanction. You can go to the courts. DPSPs have a moral and political sanction. The force is public opinion and the ballot box.
And finally, scope.
Fundamental rights are largely individualistic. They are about my rights. DPSPs are societarian. They are about the welfare of the entire community.
That is a crystal clear distinction.
It's important to remember, though, that while they differ, they're meant to be complementary. You can't have a stable, functioning democracy with just one of those wheels.
We've covered a massive amount of ground today. We've looked at the philosophy, the specific articles, the amendments, the huge conflict with fundamental rights, and the actual on-the-ground implementation.
I think the key takeaway from Chapter 9 of Laxmikanth is that while you cannot go to the High Court tomorrow and demand a uniform civil code be implemented, the government also cannot ignore that goal forever without facing real political consequences. The Constitution is designed to constantly nudge, push, and eventually force the state towards these goals through the democratic process itself.
Which leaves us with this final provocative thought for you to consider. If the DPSPs are truly the conscience of the Constitution, why are we still having such heated debates about the basic implementations of Article 44, the UCC, or Article 47 on health more than 75 years later? Is that political sanction of public opinion actually working as intended, or do we need to start thinking about making more of these principles justiciable?
That is the question that will likely define the next phase of Indian constitutionalism.
A humble reminder before you go, please subscribe to Simplified UPSC by PPP. Your support is what keeps these deep dives coming. And if you are capable, please join the paid membership on YouTube. It helps us immensely and, well, it keeps the lights on.
And remember the notes. Don't forget the notes.
Yes, the free notes, along with practice PYQs, are on our Telegram channel. But for the serious legends out there, the premium notes and those crucial model mains answers are waiting for you on the Discord channel, which is for our legend YouTube members. Do join there.
It's really worth it.
And don't forget to like this video and share your valuable comment below. Let us know what you think about that DPSP paradox. We'll see you in the next deep dive.